Leon and Cases 3, Points of Law. Trigger my mind. Augusta Regalado Wailele, Petitioner, v. People of the Philippines, Respondent. March 13, 2019. Representative from the media and a representative from the National Prosecution Service are now alternatives to each other. In People v. K, this court explained how Republic Act No. 10,640 relaxed the requirements under Section 21(1). It was relaxed with respect to the persons required to be present during the physical inventory and photographing of the seized items. Originally under Republic Act No. 9165, the use of the conjunctive and indicated that Section 21 required the presence of all of the following. In addition to the accused or the person S from whom such items were confiscated and or seized, or his/her representative or counsel. First, a representative from the media. Second, a representative from the Department of Justice, and third, any elected public official. As amended by Republic Act No. 10,640, Section 21(1) uses the disjunctive or, i.e., with an elected public official and a representative of the National Prosecution Service or the media. Thus, a representative from the media and a representative from the National Prosecution Service are now alternatives to each other. Here, none of the three people required by Section 21(1), as originally worded, was present during the physical inventory of the seized items. Moreover, this court has held that the prosecution has the positive duty to establish that earnest efforts were employed in contacting the representatives enumerated under Section 21(1) of Republic Act No. 9165, or that there was a justifiable ground for failing to do so. Yet not only did the prosecution fail to establish that earnest efforts were employed in securing the presence of the three witnesses, it did not even bother to offer any justification for the law enforcer's deviation from the law's requirements. Since preliminaries do not appear on record, this court cannot speculate why the law enforcers neglected the simple rules in the conduct of a buy-bust operation. Nonetheless, police officers are reminded that lapses like this absent any justifiable ground cast doubt on the integrity of the seized items and can be fatal to the prosecution's cause. Simeon Lapiyamahipus, Petitioner, v. People of the Philippines, Respondent. February 13, 2019. Validity of an arrest may be waived. The right to question the validity of an arrest may be waived if the accused, assisted by counsel, fails to object to its validity before arraignment. Petitioner was arrested and subjected to drug testing. When he tested positive for shabu, he was subsequently charged with having violated Article 2, Section 15 of Republic Act No. 9165, which reads, Section 15. Use of dangerous drugs. A person apprehended or arrested, who is found to be positive for use of any dangerous drug, after a confirmatory test, shall be imposed a penalty of a minimum of 6 months rehabilitation in a government center for the first offense, subject to the provisions of Article 8 of this Act. If apprehended using any dangerous drug for the second time, he/she shall suffer the penalty of imprisonment ranging from 6 years and 1 day to 12 years and a fine ranging from 50,000 pesos p50 000.00 to 200,000 pesos p200,000.00. Provided that this section shall not be applicable where the person tested is also found to have in his/her possession such quantity of any dangerous drug provided for under Section 11 of this Act, in which case the provisions stated therein shall apply. The accused were charged with possession of illegal drugs. This court not only contended with the validity of the warrantless arrest but also examined the validity of the subsequent search of the accused and the seizure of items in their possession. As with certain constitutional rights, the right to question the validity of a warrantless arrest can be waived. This waiver, however, does not carry with it a waiver of the inadmissibility of the evidence seized during the illegal arrest. Petitioner does not deny that his drug test yielded positive for illegal drugs. What he questions is the alleged illegality of his arrest. Petitioner, however, has already waived the right to question the validity of his arrest. No items were seized from him during his arrest as he was not charged with possession or sale of illegal drugs. Christine Fernandez Y. Medina, Petitioner, v. People of the Philippines, Respondent. November 21, 2018. This is an extraordinary case involving the application of doctrines on violations of Republic Act No. 7610 or the Special Protection of Children Against Child Abuse, Exploitation and Discrimination Act. That on or about November 11, 2011, in Valenzuela City and within the jurisdiction of the Honorable Court, the above-named accused being the stepmother of the herein minor victim, without any justifiable cause, did then and there willfully, unlawfully and feloniously maltreated 1 888 10 years old, DOP. September 12, 2001, complainant victim by pliers, 60 years, banging the head on the wall and punching the back of the said minor complainant victim, thereby subjecting said minor to psychological and physical abuse, cruelty and emotional maltreatment, in which act debased, degraded and demeaned his intrinsic worth and dignity as human being, thus prejudicial to his normal development. That on or about November 11, 2011, in Valenzuela City and within the jurisdiction of the Honorable Court, the above-named accused being the stepmother of that herein minor victim, without any justifiable cause, did then and there willfully, unlawfully and feloniously maltreated one BBB, 11 years old, Dob. June 5, 2000, complainant victim, by scalding her with a hot rice, sick, causing her skin to burn, piercing her stomach with a bamboo stick, hitting her eyes with a slippers, sick, hammering her foot and hitting her at the back of her body with a bamboo, thereby subjecting said minor to psychological and physical abuse, cruelty and emotional maltreatment, in which act debased, degraded and demeaned her intrinsic worth and dignity as a human being, thus prejudicial to her normal development. The prosecution proved beyond reasonable doubt that petitioner violated Republic Act No. 7610, or the Special Protection of Children Against Child Abuse, Exploitation and Discrimination Act. Under Article 1, Section 3 of law, child abuse may be committed through the following. Section 3. Definition of terms. B. Child abuse refers to the maltreatment, whether habitual or not, of the child, which includes any of the following. 1. Psychological and physical abuse, neglect, cruelty, sexual abuse and emotional maltreatment. 2. Any act by deeds or words which debases, degrades or demeans the intrinsic worth and dignity of a child as a human being. 3. Unreasonable deprivation of his basic needs for survival, such as food and shelter, or 4. Failure to immediately give medical treatment to an injured child, resulting in serious impairment of his growth and development or in his permanent incapacity or death. Article 6, Section 10, of the same law further provides. Section 10. Other acts of neglect, abuse, cruelty or exploitation and other conditions prejudicial to the child's development. A. Any person who shall commit any other acts of child abuse, cruelty or exploitation or be responsible for other conditions prejudicial to the child's development, including those covered by Article 59 of Presidential Decree No. 603, as amended, but not covered by the Revised Penal Code, as amended, shall suffer the penalty of prison in its minimum period. 35. Section 2 of the Implementing Rules and Regulations on the Reporting and Investigation of Child Abuse Cases provides the following definition of terms. Section 2. Definition of terms. A. Child abuse refers to the infliction of physical or psychological injury, cruelty to, or neglect, sexual abuse or exploitation of a child. B. Cruelty refers to any act by word or deed which debases, degrades or demeans the intrinsic worth and dignity of a child as a human being. Discipline administered by a parent or legal guardian to a child does not constitute cruelty provided it is reasonable in manner and moderate in degree and does not constitute physical or psychological injury as defined herein. C. Physical injury includes but is not limited to lacerations, fractured bones, burns, internal injuries, severe injury or serious bodily harm suffered by a child. 37. Here, records show that the minors suffered physical injuries in petitioner's hands. Milagros P. Enriquez, petitioner, v. The Mercantile Insurance Co., Inc., respondent. August 15, 2018. Contract of indemnity, surety bond. A surety bond remains effective until the action or proceeding is finally decided, resolved, or terminated, regardless of whether the applicant fails to renew the bond. The applicant will be liable to the surety for any payment the surety makes on the bond, but only up to the amount of this bond. Basic is the principle that a contract is law between the parties for as long as it is not contrary to law, morals, good customs, public order, or public policy. Under their indemnity agreement, petitioner held herself liable for any payment made by respondent by virtue of the replevin bond. A contract of insurance is by default a contract of adhesion. It is prepared by the insurance company and might contain terms and conditions too vague for a layperson to understand, hence they are construed liberally in favor of the insured. Inverendia v. Court of Appeals. Basically, a contract of indemnity, an insurance contract, is the law between the parties. Its terms and conditions constitute the measure of the insurer's liability, and compliance therewith is a condition precedent to the insured's right to recovery from the insurer. As it is also a contract of adhesion, an insurance contract should be liberally construed in favor of the insured and strictly against the insurer company which usually prepares it. July 23, 2018. Office of the Ombudsman, petitioner, v. Loving FFETALVERO, Jr., respondent. Substantial evidence. Complainants in administrative proceedings carry the burden of proving their allegations with substantial evidence or such relevant evidence that a reasonable mind might accept as adequate to support a conclusion. Dishonesty is defined as the disposition to lie, cheat, deceive, or defraud, untrustworthiness, lack of integrity. It involves intentionally making a false statement to deceive or commit a fraud. On the other hand, misconduct is more than just mere error of judgment, as it involves a wrongful intention from the public officer involved. It is also defined as a transgression of some established and definite rule of action, more particularly, unlawful behavior or gross negligence by the public officer. April 4, 2018. People of the Philippines, Plaintiff Appellee, v. Bernie Concepcion, accused appellant. Kidnapping and serious illegal detention. Articles 267 and 268 of the Revised Penal Code provide. Article 267. Kidnapping and serious illegal detention. Any private individual who shall kidnap or detain another, or in any other manner deprive him of his liberty, shall suffer the penalty of reclusion perpetua to death. 1. If the kidnapping or detention shall have lasted more than 3 days. 2. If it shall have been committed simulating public authority. 3. If any serious physical injuries shall have been inflicted upon the person kidnapped or detained, or if threats to kill him shall have been made. 4. If the person kidnapped or detained shall be a minor, except when the accused is any of the parents, female or a public officer. The penalty shall be death penalty where the kidnapping or detention was committed for the purpose of extorting ransom from the victim or any other person, even if none of the circumstances above not mentioned were present in the commission of the offense. When the victim is killed or dies as a consequence of the detention, or is raped, or is subjected to torture or dehumanizing acts, the maximum penalty shall be imposed. Article 268. Slight illegal detention. The penalty of reclusion temporal shall be imposed upon any private individual who shall commit the crimes described in the next preceding article without the attendance of any of the circumstances enumerated therein. The same penalty shall be incurred by anyone who shall furnish the place for the perpetration of the crime. If the offender shall voluntarily release the person so kidnapped or detained within 3 days from the commencement of the detention, without having attained the purpose intended, and before the institution of criminal proceedings against him, the penalty shall be prison mayor in its minimum and medium periods and a fine not exceeding 700 pesos. Thus, the felony of slight illegal detention has four elements. 1. That the offender is a private individual. 2. That he kidnaps or detains another, or in any other manner deprives him of his liberty. 3. That the act of kidnapping or detention is illegal. 4. That the crime is committed without the attendance of any of the circumstances enumerated in Article 267. April 18, 2018. Makati Tuscany Condominium Corporation, Petitioner, v. Multi-Realty Development Corporation, Respondent. Reformation of an instrument. Reformation of an instrument may be allowed if subsequent and contemporaneous acts of the parties show that their true intention was not accurately reflected in the written instrument. The National Irrigation Administration v. Gamut stated that there must be a concurrence of the following requisites for an action for reformation of instrument to prosper. 1. There must have been a meeting of the minds of the parties to the contract. 2. The instrument does not express the true intention of the parties, and 3. The failure of the instrument to express the true intention of the parties is due to mistake, fraud, inequitable conduct, or accident. The burden of proof then rests upon the party asking for the reformation of the instrument to overturn the presumption that a written instrument already sets out the true intentions of the contracting parties. Doctrine of res judicata. There is res judicata when the following concur. The former judgment must be final. B. The court which rendered judgment had jurisdiction over the parties and the subject matter. C. It must be a judgment on the merits. D. And there must be between the first and second actions identity of parties, subject matter, and cause of action. Doctrine of estoppel. In Philippine National Bank v. Court of Appeals, this court held the doctrine of estoppel is based upon the grounds of public policy, fair dealing, good faith and justice, and its purpose is to forbid one to speak against his own act, representations, or commitments to the injury of one to whom they were directed and who reasonably relied thereon. The doctrine of estoppel springs from equitable principles and the equities in the case. It is designed to aid the law in the administration of justice where without its aid injustice might result. It has been applied by this court wherever and whenever special circumstances of a case so demand. November 22, 2017. Commissioner of Internal Revenue Petitioner v. Transitions Philippines, Optical Inc., Respondent. Doctrine of estoppel. Estoppel applies against a taxpayer who did not only raise at the earliest opportunity its representative's lack of authority to execute two waivers of defense of prescription, but was also accorded through these waivers more time to comply with the audit requirements of the Bureau of Internal Revenue. Nonetheless, a tax assessment served beyond the extended period is void. PAN and FAN. A PAN merely informs the taxpayer of the initial findings of the Bureau of Internal Revenue. It contains the proposed assessment and the facts, law, rules, and regulations or jurisprudence on which the proposed assessment is based. It does not contain a demand for payment but usually requires the taxpayer to reply within 15 days from receipt. Otherwise, the Commissioner of Internal Revenue will finalize an assessment and issue a FAN. A FAN contains not only a computation of tax liabilities but also a demand for payment within a prescribed period. As soon as it is served, an obligation arises on the part of the taxpayer concerned to pay the amount assessed and demanded. It also signals the time when penalties and interests begin to accrue against the taxpayer. Failure to file an administrative protest within 30 days from receipt of the FAN will render the assessment final, executory, and demandable. November 8, 2017. Personal Collection Direct Selling, Inc. Petitioner, v. Teresita L. Carandong, Respondent. Lack of probable cause. Judges must act with cautious discernment and faithfully exercise their judicial discretion when dismissing cases for lack of probable cause. In order granting the withdrawal of an information based on the prosecutor's findings of lack of probable cause must show that the judge did not rely solely on the prosecution's conclusions but had independently evaluated the evidence on record and the merits of the case. Information. When information is filed in court, the court acquires jurisdiction over the case and has the authority to determine, among others, whether or not the case should be dismissed. The court is the best and sole judge of what to do with the case before it. The dismissal of a criminal case due to lack of probable cause protects the accused from having to undergo trial based on insufficient evidence. Determination of probable cause. Although there is no general formula or fixed rule for the determination of probable cause since the same must be decided in the light of the conditions obtaining in given situations and its existence depends to a large degree upon the finding or opinion of the judge conducting the examination. Such a finding should not disregard the facts before the judge nor run counter to the clear dictates of reasons. The judge or fiscal, therefore, should not go on with the prosecution in the hope that some credible evidence might later turn up during trial, for this would be a flagrant violation of a basic right which the courts are created to uphold. It bears repeating that the judiciary lives up to its mission by vitalizing and not denigrating constitutional rights. So it has been before. It should continue to be so. Judges must proceed with caution in dismissing cases for lack of probable cause since the evidence before them are preliminary in nature. When probable cause exists, the court must proceed with arraignment and trial. But should the evidence presented absolutely fail to support this finding of probable cause, the case should be dismissed. Whether it is to dismiss the case or to proceed with trial, a judge's action must not impair the substantial rights of the accused, or the right of the state and the offended party to due process of law. Judges must act with cautious discernment when asked to dismiss cases on the ground of the absence of probable cause to support the withdrawal or dismissal of information. While the accused is constitutionally given a guarantee of presumption of innocence, there is also the concern for the right to due process of the prosecution. The balance in each case is not theoretical. Rather, it will be the outcome of the proper appreciation of the evidence presented and a conscientious application by the judge of the proper burdens of proof and evidence. Likewise, the trial court must consider that trial is always available after arraignment and is a forum for the accused as much as it is for the prosecution to carefully examine the merits of the case. As a general proposition, once the information is filed and a warrant is issued after a judicial determination of probable cause, subsequent technical dismissals are inequitable and should generally be avoided. Thus, in granting or denying a motion to withdraw an information, the court must conduct a cautious and independent evaluation of the evidence of the prosecution and must be convinced that the merits of the case warrant either the dismissal or continuation of the action. The trial court correctly granted the release of respondent's cash bond. Petitioner's right to due process was not violated when it was not given notice or an opportunity to be heard on the motion to release cash bond. No notice or hearing was necessary since the bail was automatically cancelled upon the dismissal of the case. Petitioner's hypothetical objections to the motion to release cash bond would have been superfluous and unnecessary since the release of the cash bond to respondent was already warranted under the Rules of Court. October 4, 2017. Office of the Ombudsman. Petitioner, v. Antonio Z. de Guzman, Respondent. Lack of authority. The Postmaster General may only execute contracts for procurement of services with the Board of Directors' approval. However, this lack of authority may be ratified through the Board of Directors' silence or acquiescence. The ratification of the unauthorized act does not necessarily mean that the contract is valid. If the contract is executed without complying with the laws on procurement, the erring public official may be held administratively liable. Respondent, as the acting Postmaster General, had the duty to first secure the Board of Directors' approval before entering into the May 7, 2004 contract with Avoidus. 1. The Board of Directors did not actually give its approval since it required him to first fulfill certain conditions. Instead of complying, he went ahead and executed the contract with Avoidus 1 without ensuring that the procurement of its services by the Philippine Postal Corporation would be done through the proper procedures and at the most advantageous price. Accordingly, he is found guilty of gross neglect of duty. Under Rule 10, Section 46, A2 of the Revised Rules on Administrative Cases, gross neglect of duty is categorized as a grave offense punishable by dismissal from service. In view of the constitutional principle that public office is a public trust, erring public officials must be held accountable not for punishment but to ensure the public's continued trust and confidence in the civil service. See Avenito v. Civil Service Commission, 576 Phil. 654, 661, 2008, per curiam, and bank, where this court stated that the designation of the offense or offenses with which a person is charged in an administrative case is not controlling and one may be found guilty of another offense where the substance OFTHF, allegations and evidence presented sufficiently proves one's guilt. August 9, 2017 People of the Philippines, Plaintiff Appellee, v. Delia Saunar, accused appellant. Chain of custody. A minuscule amount of dangerous drugs alleged to have been taken from the accused is highly susceptible to planting, tampering, or alteration. In these cases, law enforcers should not trifle with the legal requirement to ensure integrity in the chain of custody of seized dangerous drugs and drug paraphernalia. Aside from this, the corpus delicti must be presented as evidence in court. In cases involving dangerous drugs, the corpus delicti is the dangerous drug itself. Hence, its identity and integrity must likewise be established beyond reasonable doubt. The obligation of the prosecution is to ensure that the illegal drugs offered in court are the very same items seized from the accused. This would entail the presentation of evidence on how the seized drugs were handled and preserved from the moment they were confiscated from the accused until their presentation in court. Non-compliance with this requirement creates doubt regarding the origin of the dangerous drugs. Although chain of custody is not specifically defined under the law, the term essentially refers to the duly recorded authorized movements and custody of seized drugs or controlled chemicals or plant sources of dangerous drugs or laboratory equipment of each stage, from the time of seizure confiscation to receipt in the forensic laboratory to safekeeping to presentation in court for destruction. Such record of movements and custody of seized item shall include the identity and signature of the person who held temporary custody of the seized item, the date and time when such transfer of custody were made in the course of safekeeping and use in court as evidence, and the final disposition. Duly recorded authorized movements of the seized dangerous drugs may be ascertained through the testimonies of every person who handled them. Maliland v. People is instructive as a method of authenticating evidence. The chain of custody rule requires that the admission of an exhibit be preceded by evidence sufficient to support a finding that the matter in question is what the proponent claims it to be. It would include testimony about every link in the chain from the moment the item was picked up to the time it is offered into evidence, in such a way that every person who touched the exhibit would describe how and from whom it was received, where it was and what happened to it while in the witness possession, the condition in which it was received and the condition in which it was delivered to the next link in the chain. These witnesses would then describe the precautions taken to ensure that there had been no change in the condition of the item and no opportunity for someone not in the chain to have possession of the same. August 2, 2017 People of the Philippines, Plaintiff Appellee, BPO3 Julieto Borja, accused appellant. Public officer is acting in private capacity. Extortion done by police themselves amounting to kidnapping with ransom undermines the government efforts to establish the rule of law in general and the proper prosecution against drug traffickers. In particular, even the subsequent prosecution of the victim of extortion does not negate the criminal liability of the accused for the crime the latter committed against the former. A conviction for the crime of kidnapping or serious illegal detention requires the concurrence of the following elements. 1. The offender is a private individual. 2. That individual kidnaps or detains another or in any other manner deprives the latter of liberty. 3. 3. The act of detention or kidnapping is illegal. 4. In the commission of the offense, any of the following circumstances is present. A. The kidnapping or detention lasts for more than 3 days. B. It is committed by one who simulates public authority. C. Any serious physical injury is inflicted upon the person kidnapped or detained, or any threat to kill that person is made. D. The person kidnapped or detained is a minor, a female or a public officer. Although the crime of kidnapping can only be committed by a private individual, the fact that the accused is a public official does not automatically preclude the filing of an information for kidnapping against him. A public officer who detains a person for the purpose of extorting ransom cannot be said to be acting in an official capacity. In People v. Santillano, 53, this court explained that public officials may be prosecuted under Article 267 of the Revised Penal Code if they act in their private capacity. The fact alone that Appellant Pueta is an organic member of the NARCOM and Appellant Sandigan, a regular member of the PNP, would not exempt them from the criminal liability for kidnapping. It is quite clear that in abducting and taking away the victim, appellants did so neither in furtherance of official function nor in the pursuit of authority vested in them. It is not, in fine, in relation to their office but in purely private capacity, that they have acted in concert with their co-appellant Santillano and Chanco. All the elements of kidnapping were sufficiently proven by the prosecution, which cannot be overturned by accused appellants' bare denial and alibi. These two defenses are inherently weak considering that they can be easily contrived. For the defense of alibi to prosper, there must be a showing that it was physically impossible for the accused to have been at the scene of the crime at the time of its commission. In the present case, accused appellant failed to overcome this standard. Even if he attended the hearing in Quezon City Hall of Justice, there is no showing that it was physically impossible for him to be at Agam Road when the victim was forcibly taken. This court takes judicial notice that Agam Road and the Quezon City Hall of Justice are just a few blocks away from each other. Accused appellant could have easily slipped out of the City Hall at any time. Moreover, if this court were to believe accused appellant's version of the incident, it was highly irregular for a police officer to meet the victim's relative in a place other than the police station to discuss the incident reported to him. That he had to wait for 30 minutes for another person to arrive is also suspect. Moreover, as pointed out by the Office of the Solicitor General, it is unusual for accused appellant to interfere with an ongoing operation to which he was not assigned. All these irregularities point to the reasonable conclusion that accused appellant's purpose in proceeding to the wildlife park was to extort money from the victim's family. Proof beyond reasonable doubt. Rules of Court Rule 133, Sec. 2 provides, Section 2, proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal, unless his guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof as, excluding the possibility of error, produces absolute certainty. Moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind.